is really a great starting place for you to build your work. But there is no guarantee from OpenAI or any other AI solution services provider that the output is not going to get you into trouble. It could. So that's why verification is really important. And if you read it and say, wow, this sounds really like that poem that I read last week that Jennifer Stanley wrote at that poetry recital that I went to, it could, if it's my poem, then it is there's good arguments that you're infringing. So on the right of publicity, so the right of publicity is the right of any of us, not only famous people, we all enjoy right of publicity, to commercialize our name, image, likeness, persona, voice, mannerisms, any of those things. So famous or well-known people tend to be the people who enforce their rights of publicity because they generate their living out of it, but we all enjoy the benefit of it, actually. And so using a solution to mimic somebody, you know, in many cases is going to violate their right of publicity. But, you know, to echo what Ashley said at the beginning, this is not new ground. There have been sound-alike cases.
Think about when they are drafting their own terms and conditions. And if there's anything that they should 100% include in their T's and C's, no matter what the use case is. And Adine, I know that you are, you know, working with startups day in and day out, and really in those terms and conditions, we would love if you could start with this question.
Yeah, absolutely. So I wanted to highlight for this question 3 themes to consider. So first is, we've spoken a lot in this panel about inputs and outputs. So it's really important that you're thinking about which rights you need for both and which rights you have to assign for inputs and outputs. So for inputs, for example, do you need a right to use that input to further train your AI model? If you're gonna have a lot of enterprise clients or businesses, they may not want that, and you're gonna have to consider in your business model whether that's acceptable, or whether to have maybe a compromise position, like, fine, we can't use your inputs, but maybe we could use the derived insights or derived signals from your inputs to further train it. Because sometimes with these AI models, as you know, to further train it, the more specific you get may not be helpful. It's probably the more derived stuff that could be helpful. So that's one way to approach that.
Hearings on generative AI and the discussion around EU's first ever legal framework on artificial intelligence, it is natural for startups to wonder how potential regulations will help or hinder their company and innovation. So our first question is, we're aware that there have been recent regulatory developments in generative AI. Can you guys discuss which ones have the most impact on startups and why? And Adine, we'll have you kick off this question.
So for example, at OpenAI, right, we have a lot, I'm sure you've seen in the news, a lot of privacy regulatory investigations, and those regulators are applying current laws to OpenAI. They're not applying future AI laws. It's not AI specific, right? This isn't just, you know, these products and services are regulated by existing laws.
I am supporting in the trenches with the engineers and the marketers and our designers and our product teams, really making sure that our app is illegal. And I organized this just on my own. I'm interested in this. I want to democratize the information to this, and I'm hoping to transition my practice into generative AI. So I'm just super excited to be here, and I will kick it over to Ashley.
Hi, I'm Ashley Pantoliano. I'm an Associate General Counsel at OpenAI. I focus on product counseling and privacy counseling. So I basically advise our company on legal risk when they think about launching products.
At the risk of really making a pun here, I wouldn't input the question into an AI text generation tool and then rely on the answer. There was a lawyer, if any of you read the article in the New York Times over the weekend, there was a lawyer who did that in a case and cited fake cases, and the judge and opposing counsel couldn't figure out where these cases came from, and now that lawyer and his colleagues are either subject to discipline, or I loved the last line in the article, which was, or asked to explain why they thought it was okay to use an AI text generation tool to do some legal research. So
section of generative AI and blockchain. So up is just copyright considerations around creators using generative AI originated content and using that in their material, social media, creating a digital work, NFTs, blockchain, and like what should be, like what are the legal protections, what should we be thinking about?
So that's a great segue.
Yeah, it is. It's a great segue, and we can, if everyone wants to feel free to just kind of just jump in, and then I'll follow up some of the other questions. Do you want to jump in on that answer?
I can start if you like. So if we think about content, so most content is protected by copyright here in the US. So copyright.
Again, it depends on the terms of use of the tool that you're using. So for OpenAI, ChatGPT, users own their input and output, but you should review the terms of use of the tool because you could end up assigning whatever rights you have in that data to the company when you put it into the tool. That would be a pretty bad business practice on the part of an AI tool, so I would, because then no one would want to use their tool, so I would guess that most people wouldn't have that in their terms, but I would definitely check that. And my last response is to think about like the real world harm that comes from whatever it is you're doing. I think a lot of legal risk follows from that. And so you can, look at something and think about your product, and then take the worst person that you can think of, and what are they going to do with your product?
Models, like they're probably using heuristics. They probably have some type of inherent performance issues. You probably have heard about the hallucination effect for some of these AI models. Be clear about that. Be clear if you put an input or two different inputs, it may generate the same type of output. That's another example. Training data. It's a risk to navigate, but you're going to want to talk, and it's important, especially if you're using PII, which is personally identifiable information. You're going to navigate what consents you need with your lawyer and what's the appropriate risk level to take if you don't have all those consents. And there's some AI models that are doing it a little bit retrospectively. So Stable Diffusion is now offering artists an opportunity to opt out of using their artwork for training data going forward. So they're thinking about that. And the risk here is that in some rare cases, and these are more edge case, but the FTC has scared about inputting like trade secrets or leakage of confidential or sensitive information. Try to look for either OpenAI's model where you could opt out or use it via an API, which Ashley can of course talk about as well, or look for those enterprise versions where you could really put in more sensitive information.
Technology to be more efficient. There's a lot of risk. We are looking at tools, we and many other firms like us, but we have to make sure that we're relying on a closed data set that is accurate and kind of moderated by a human who's a lawyer. But I do think that there's a very powerful use case to use in big law. We already use we use various tools for analyzing documents. We've done that for years actually before this revolution. But the good news is I think will reduce legal cost, which is good. We want to be more efficient.